Welcome to another episode of the Best Florida Family Law Podcast. My name is Attorney Jonathan Jacobs of the Jacobs Law Firm. I'm so happy to be here with you today to discuss yet another fascinating topic in Florida family law. I'm going to discuss this in a hypothetical manner. Please do not mistake this with the facts of your case, as every case is different and unique, and this is not legal advice. This is simply referential and intended for entertainment purposes and to maybe educate you about Florida law. Let's rock and roll. Florida Statute 6108 is Florida's new alimony statute. It has since been revised since 2023 when the new laws came down from the Florida Supreme Court, the Florida Legislature. All of this is now established law. So for those of you who are new to the party, maybe contemplating a divorce, are about to be in the throes of a divorce, or are creating a postnuptial agreement, here we go. First, the court must find that one party has the ability to pay alimony and must find that the other party has a legitimate need for that spousal support. Here are the factors that the court must consider. The duration of the marriage, which is what we are going to talk about here this morning, the standard of living established during the marriage, and here, do not forget the second part of this sentence, and the anticipated needs and necessities of life after the entry of final judgment. This is not the wants, the hopes, the dreams, the fleecing of the other party. This is the anticipated needs and necessities. You must prove what your needs are post-dissolution. The age, physical, mental, and emotional condition of each party. If somebody is disabled, for example, can they work? What are their work prospects? Are they too old to work? Are they past the age of retirement? Are they young and able-bodied? Each party's resources, including income generated from non-marital assets. Maybe the party asking for alimony has a trust fund and has superior funds compared to the other party, at least going into a trust fund, and that they have access to. The earnings capacities of each party. Can somebody earn $200,000 a year even though they're now earning minimum wage? Maybe. What is their employability? What sort of education do they have? Are they self-supporting post-divorce? The contribution of each party to the marriage, including homemaking, childcare, and this one is my favorite, career building of the other party. Oftentimes, even though both parties can have a successful career, one of those parties, dad or mom, will decide, hey, you know what? I'm going to stay home with the kids, at least for the first several years of their lives, to give them a good head start until they're in elementary school or whatnot. You go ahead, establish your career, you be the breadwinner, you make a living for the family, and we will each play an equally important role in the building of our family. And of course, the catch-all, any other factor necessary for equity and justice between the parties. These all must have written findings of fact. Okay, here's the question, though. One of our listeners sent this question in. What if they've been involved in a short-term marriage? And not just a short-term marriage, but a short-term marriage. And what do I mean by that? According to the same statute, there's a rebuttable, which means you can overcome it, presumption that a short-term marriage is 10 years or less. So really, let's take it as 9 years, 364 days or less. If that is the case, and somebody has been married for under 10 years, then the statutory maximum applies. If they are found to owe the statutory maximum of alimony, that would be for a length of 50% of the length of their marriage. Approximately, if you've been married for 9 years and 64 days, 9 years, 364 days, then the other party might owe you 4 years and 11 months of alimony or some such number at a maximum. And of course, the amount remains about 35% of the difference in your two respective incomes. But that really isn't the focus here today. Of course, throughout our podcast and over time, we are going to tease out information about every one of these things. For right now, I want to address this particular individual's, who shall remain anonymous, of course, question for us. What happens if they've been married for less than 3 years? Well, let's find out. Can they obtain durational alimony if they've been married for less than 3 years? Here we go. An award of durational alimony terminates upon the death of either party or the remarriage of the person paying. The amount of durational alimony may be modified or terminated based on a substantial change in circumstances. And here we go. The statute tells us a bright line rule. Durational alimony may not be awarded following a marriage lasting less than 3 years. Okay. So if you've been married for 2.5 years, 2 years and 11 months, the statute provides that durational alimony is not something that you can obtain. So if you've been married for less than 3 years, what kinds of alimony might be available to you? One is rehabilitative alimony, to assist you in establishing self-support. In other words, maybe you go back to school, get your AA or GED or college degree, a technical degree, maybe become somebody who works in the medical field, somebody who works in the educational field. You go back to school so that you can support yourself. And is rehabilitative alimony going to be for a full 3 years? Probably not. I suppose that the judge might award rehabilitative alimony for 6 months, a year and a half if you've been married less than 3 years, depending on how long it takes you to establish your new career. And of course, what is fair and equitable? It's probably not fair and equitable to make somebody pay alimony for the length of their marriage. That doesn't seem fair and equitable, but every judge rules differently. What else might be available? Bridge the gap alimony. What if you have to make that transition from being married to being single? Bridge the gap alimony is intended to cover your short-term needs, sort of like a severance check, if you can think about that. Let's say that you have, this is a different amount of time, but let's say that you've been working for the same company for 15 years and you get laid off. Maybe that company offers you a severance check, which will cover the next several months until you find replacement employment. That's really bridge the gap alimony. Is you're going from married to single, you can have a job, you do have job skills, you just need to actually find that job, and how long is that likely to take? Whereas that rehabilitative alimony we just discussed a minute ago, rehabilitative means building you back up. If you haven't worked in 15 years, although we're talking about a less than 3-year marriage, but it's still possible if you've been married for a short term that you haven't worked in a long time, you might need a new education, you might need new credentials, you might need to get a teaching certificate. There are so many different things that you might need. And to that effect, you're going to have to be rehabilitated. So let's try to do some calculations. If you earn, let's say, $100,000 a year, and your spouse is not currently working, and they still have the ability to work, even if they're in, let's say, their 40s or 50s, they're gray-haired, grizzled peeps like me. I'm 44, turning 45 soon. They still have the ability and the able-bodiedness to go ahead and get a career and be self-supportive. Well then, they're probably not going to get that durational alimony in a marriage of less than 3 years. If they have an education, they're probably not going to get rehabilitative alimony. They're more likely to get bridge the gap alimony to transition to single life. And then we look to all those statutory factors that we talked about. What was the standard of living? Was it so high that you just can't replace it that easily? Was it that you made career sacrifices for the other party in helping raise their children? Was it that you were accustomed to a standard of living that was just so grandiose that it's going to be very difficult to make that transition? What sacrifices did you make? What is your likelihood of working long term? What is your skill set? And so on and so forth. All of these things are worth considering. There is no absolute answer. The only time we would have an absolute answer is after we have your financial documents, the other party's financial documents, both attorneys and their clients come up with a settlement, or at some point a case goes to trial and the judge makes that determination. Thank you for listening. This has been another episode of the Best Florida Family Law Podcast. This is not legal advice. Anything we've talked about is strictly hypothetical. We hope that you've been informed and entertained. Thank you so much. See you next time.